We've got a docket update, Boonies. So let's get into this. Show you guys first the docket. All right, so it looks like we've got the court minutes here, which we've kind of been. I'm still doing a couple of videos to talk about their hearing, which was so entertaining from Thursday. We got the final from the Justice Administration, I think. Now, as Salmon explained to us, this nunc pro tunc basically means that they're going back retroactively. So Billy Lane has been on this case for a while. He's did some work and he hasn't gotten paid for it yet, and he hadn't put in the time yet. So now they got to go back to August 30 and say, okay, yeah, we're going to give him more time. Billy's making some bank on this case, but I can tell you, actually, it's probably not that much, but he's probably worked his butt off on this case. So they're just going back and saying, look, he did this work on these dates, and we're putting in for you to go back and change your motion or change your approval on this to more money or to pay him for this extra stuff that he did. I'm probably making that more difficult than it is when I explain it, but I didn't want to skip over any documents. The next motion that we've got is from the state, Cacciatore, motion for court-appointed experts to produce reports. The defense filed motions for the Dr. Michael Brannon and Dr. Michael Birkeland on September the 18th of 2024. The court granted the motion to appoint those doctors on the 19th, which was Thursday during the hearing. The state requested that these doctors provide written reports prior to trial. The defense objects to this request by the state. Neither Dr. Brannon nor Dr. Birkeland were listed on the defense's amended witness list in this case. The state had not previously had an attorney to depose them. The case at bar is currently set for October the 7th of 2024. Therefore, the state would request that both Dr. Brannon and Birkeland provide written reports regarding their findings to the state and the defense prior to the close of business on the 26th. That's kind of interesting that they said the date of the hearing, because that's when they have their pretrial conference hearing. They furnished a copy to James Owens. Surely the state's investigator is going to find all that stuff on Birkeland. Somebody said, share your video with them. I'm like, they know. They do this for a living. They're good. They better bring it up. If they don't, I'm going to email the judge. No, I'm just kidding. I'm going to write the judge a letter. Just kidding. Let's see. Court appointed experts to produce reports. Got that. Order appointing experts. So he granted them, which we knew. So this is basically, yeah, he's getting the money from the JSC to do all this. So we got Harper approved. I don't know why they just don't put all these in one thing. Wouldn't it make it easier, Judge? This is the court minutes. I'm not going to go into this because I've got other things that I want to look at, because there's something even more important that we need to look at here. We really don't need to open all these documents for me to explain this to you guys. I think at this point you guys get it. If I've got it, you've got it. They basically, okay, order granting to appoint clinical psychologist Julie Harper, order granting to appoint crime scene reconstructionist Birkeland. Well, he's a crime scene reconstructionist and death investigator. The infamous Dr. Michael Birkeland, who has quite the history. Correspondence received from the judge. What is this? Concerns of U.S. Oh, Lord have mercy. Stop the presses. We got somebody over in Iowa wanting their 5 minutes of fame. All right, so let's just read this, and I'm going to read it, and if it starts to get crazy, I'm walking away. Dear Judge Cranick, I have been closely following developments in defendant Sarah Boone's case, who is accused of second-degree. I forgot to share with y'all. Here it is. Obviously, she knows that when she's putting this up on the docket, it's public record, so I'm not even going to hide her address. I have been closely following developments in defendant Sarah Boone's case, who is accused of second-degree murder, and I find her predicament very troubling. It is evident that Sarah Boone is a difficult inmate who, per your decision, has forfeited her right to counsel. It is an appropriate conclusion. When did she write? Oh, she wrote this on the August 27th, just by the way. That's a while back here. It is an appropriate conclusion, for though the right to court-appointed counsel is constitutionally guaranteed, the defendant does not have a right to shop for one ad infinitum. What is that word? Infinitum? They're going to make me look it up. Why do these people need to use these words? Infinitum. I know it means infinitely, but why can't she just say infinitely? Why does she got to say that word? Ad infinitum. According to Google, the proper way to say that is ad infinitum, which means again and again and again. These people. Until she finds the right fit. Right, girl? It's not like they're shoes. There are, however, some concerns and considerations which I fear will jeopardize the defendant's right to an unfair trial, which perhaps have never been raised before. I want to just stop this right here and just say to you guys, so you've got a judge here who has this immaculate background. We've already gone over the background of the judge. We've already gone over how many years this man has been practicing law and has been on the bench, okay? And this person from Iowa is going to just come in there and tell him how to do his job. The fact that this is even allowed, he probably read this first paragraph and then put it down. Honestly, he doesn't even have to read this. I don't think his clerk could read it and be like, you don't need to see that, judge. We must first recognize, as you are personally well aware, that no person in the state of Florida, nor in any state of these United States, is allowed to legally perform the duties of an attorney without a legal law license for which one has to pass a bar exam. The simple fact underscores the depth of education, experience, and savvy which are necessary for an individual to represent another individual or entity. But of course, these are 21st century considerations which take into account the complicated world in which we live in today and which were not on any of the founding fathers' radars. Oh, you mean like writing to the judge so that you can get it on the docket so that people will put you out there? Expecting a lay person to be able to competently represent themselves in 2024 and with no accommodations would be. Oh, okay. You're saying so her representing herself is the same as her giving a medical surgery on somebody on themselves. No, it's not. This would consider inhumane. You guys, I know this is making y'all fume because it's making me fume reading it. I don't think this person deserves any more of my time. But I would venture to argue even further that the Constitution also doesn't guarantee the defendant the right to medical treatment, meals, or even personal hygiene supplies or clothing. It's just that we the people have collectively decided that human rights and the dignity of the individual matter and that they supersede any constitution or state charter, and thus it is for the betterment of all to honor them, for we might one day find ourselves at the mercy of the law and its enforcers. As long as the state is responsible for the care and housing of any inmate, pro se or not, we must also afford them a path to properly exercise their constitutional rights in 2024, not just in 1787. Okay, this person has been drinking the Kool-Aid. I think she got the cherry flavor, and she's all in. Honey, just stop now. Just stop now. Okay, that's all I'm going to say about that one. Oh, my word. Now, the states, there was a motion. I want to go back because remember I told you guys that sometimes when they'll put stuff up on the docket, it might be a response that dates back. Well, when they upload it to the docket, they put it in the order that it was dated, which is kind of confusing because then we can't keep up with when it was added to the docket. So let me just take a moment here to look through this and make sure. We've already looked through the state's response on that. Motion to strike, we've looked on that. Notice of provision of witness list, notice of hearing, notice of appearance, notice of filing. Notice of provision of defendant's exhibit list. They're required to do that, so that's not a big deal. Let's see what else. So then the state filed this. Yeah, so they did this on Friday. Let's look at what the state said. They're talking about them wanting to rely on the battered spouse syndrome. It says the defendant filed an amended notice of intent to rely on the defense of battered spouse syndrome on September the 15th of 2024. The defendant was provided discovery over 4 years ago. By the defendant's own admission, her expert, Dr. Julie Harper, saw her in 2020. The discovery in this case shows that the decedent and the defendant engaged in the alcohol-infused spats of violence against one another periodically. So is this what he just said basically when he got up in court? This no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the McNaughton rule. Oh, boom. The conclusion statement that in particular, if the evidence will demonstrate factors that trigger battered women's syndrome, the physical symptoms experienced during battered women's syndrome, the distinct behavior and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from battered women's syndrome, and the impact of battered women's syndrome as it relates to the facts of this case, does not set forth the particular evidence that shows the defendant suffered from this syndrome. The state's concerned that what the defendant is alleging does not meet the criteria for battered spouse syndrome is not premature. The discovery does not support a diagnosis of battered spouse syndrome, and the defendant has not alleged new facts to support battered spouse syndrome. Battered spouse syndrome is not actually a defense to a crime. Oh, okay. Is this cacciatore or this is Mr. J? I bet. This is Mr. J. Yep, you go, Mr. J. I really need to get a picture of him and put it up here. The introduction of a battered spouse syndrome evidence to support a self defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why keyword, the defendant's actions were reasonable, to show in spite of a reasonable perception of danger from the battering spouse, the battered defendant would remain in the home with her batterer where she may resort to the extortion of force against him to prevent, again, keyword, imminent death, imminent threat, it doesn't say threat, but that's what, or great bodily harm. And this is true, you guys. We say this all the time. Why would you stay with him? Why do you stay with a battered person? Why don't you leave? Instead of harming him, why don't you leave? And this is where they're saying, because you have that mentality that you can't leave. It's the mentality of the abused, which has been proven over and over and over again. Okay. So then he references a couple of cases here. Again, that wind case comes up. There is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any such new evidence in her notice of intent to rely on battered spouse evidence. What the defendant told law enforcement was, when asked about the decedent's other injuries, in all honesty, we had gotten into it. That's what she said in the statement. Oh, I love how he pulls that out. Can I highlight that, Judge? Right here. Right there. That's beauty, miss. That's so pretty. The defendant said she and the decedent were having a good time on Sunday. Well, actually, she said good day, but okay. Having wine, painting, doing puzzles, and listening to music. Nobody laid a hand on nobody. I really like this Mr. J, y'all. I wish I could interview him. He would be so good to have on. I have not touched him. We had a good day. It was a good day. We've had good days lately. There was no ill will between us last night. Last argument was maybe last week. I was so happy. It was such a good day. I kid you not. I love this. Oh, this is great. This is fabulous. Nobody touched nobody. Nobody touched nobody. Can y'all hear her saying this? Because y'all have watched the interrogation so many times. If y'all are hearing this as I'm reading it and you're hearing her voice saying it, I'm with you on that because I am too. It's the drinking. That's what it is. It's the drinking. I thought it was like, I thought it was okay. Maybe I should read this. Okay, let's go back. I've got to read this as if Sarah was saying it. Okay. So, in all honesty, we'd gotten into it. Nobody laid a hand on nobody. I have not touched him. We had a good day. It was a good day. We've had good days lately. There was no ill will between us last night. Our last argument was maybe like last week. I was can I tell you I was so happy. Like it was such a good day. I kid you not. Nobody touched nobody. Nobody touched nobody. It's the drinking. That's what it is. It's the drinking. I thought it was like I thought he was okay. Everything was fine and dandy. Why didn't you just let him out, Sarah? Uh, I to be honest with you, I mean, I don't know. I forgot what that word. You tell me and we'll both know. That's not what it says. I just had to say that. I will never drink alcohol again. What was the motivation for leaving him in the back, Sarah? I, di- I didn't have any motivation. It was me. He and I having a great day, fooling around and being stupid. And apparently, me going upstairs and going, I guess, I'm guessing, I mean, I'm blaming it on the wine. You two didn't lay hands on each other. No, no. I mean, obviously, I don't have any injuries. Exactly, Sarah. He and I have not been at it with one another. She didn't do this intentionally. It was not intentional. Alcohol, okay, alcohol is a shitty thing. So it's like, okay, while we're in a good place right now, I'm going to snap. Is that what it is? While we were in a good place right now, I'm going to do that. See, the thing is too, but you clearly can tell that I had been drinking some. I did not touch him, nor did he touch me. And we continue. Okay, and that's my interpretation. Then prosecutor Jay goes on to say, the defendant's account is not one of self-defense, but rather an accident. If the defendant has changed her account, she has not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. It says BSS is not in itself a legal defense, but evidence that the defendant suffered from BSS is admissible in Florida to support the claim of self-defense when the defendant is charged with a crime against her abuser. If the defendant has changed her accounts of that day, okay, so is he saying, do we need to re-interview Sarah? That's what that seems like to me. I I don't know, guys. I feel like, why wouldn't they go ahead and let her just do it? Are they scared that that could trigger a juror to say, "Oh, but she was battered, so we don't want to take that chance. We're going to fight this now instead of fighting it on the stand." Because I do feel like anything that they say, they can combat it with all of this documentation that we have on video and audio of Sarah that would just go against this battered spouse syndrome. It's going to make her and her defense team and anybody that gets up on the stand and says otherwise, it's going to discredit them. So I don't know. I just feel like maybe somebody else with legal strategy can explain that better. Therefore, the state renews its request for this court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. Additionally, the state renews its request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. They reference Ladd versus State. They're wanting to talk to Dr. Harper. All right, so Dr. Julie Harper is the one that, for those of you that are new to this, Dr. Julie Harper is the one that the defense has hired. She's a psychologist to claim that Sarah has battered spouse syndrome. The state has a deposition for her scheduled on October the 1st. I find it interesting that they're going ahead with what they're saying here before they depose her. But, I mean, I get it. Why take that chance? Defendant's argument is that the trial court thereby improperly required a defendant to testify. We disagree. The trial court did not err in determining that no other testimony provided a predicate for that expert testimony. Thus far, the state is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the decedent and the defendant. There is zero evidence that there was a justifiable use of deadly force. The defendant has stated the exact opposite, and she is the only one who can testify that it was a justifiable use of deadly force. Okay, I'm starting to understand what he's trying to say here. This is common sense, but sometimes when you read it in the legal pieces, it kind of takes you out of the realm of that. So she wasn't under duress. She wasn't in imminent danger at the time of all this happening. They were having a good day. Therefore, to say that she did this, but I mean, I can kind of lean towards the fact of BSS. Okay, but what she said in that video, that suitcase video, you guys, for everything you've done to me, if taken out of the wrong context, that could look to a juror as, oh yeah, she finally got him where she wanted him, and she was able to do this because he couldn't come back at her. You know what I mean? This is me speculating stuff. If you're new to this channel, I'm not an attorney. I just speculate and try to understand it in layman terms. All right, so then I see amended notice of hearing, notice of supplementary discovery. This was also put up on the 19th. The inmate tablet communication records. Oh, there's a ton of them. Page 424 through 891. Holy crap. So they mailed these copies to Owens. I love that they mailed them. It's such a lawyer thing. It's like, okay, you want this? Okay, I'll give it to you, but I'm not going to email it to you. It's too big of a document. Supposedly. I'll mail it to you. And two, you're going to have to go through it because we're not going to piece any of that out for you. Oh, so they sent them the copies of the inmate tablet communication records, okay? It's going to be interesting to see what she's looking at. She's probably, she can't get internet on there, right? But it's like Sam had said, there's a lot of correspondence going on between her and maybe Billy Lane, maybe her attorneys at the time, whichever ones they were on at the time. Yeah, it might be kind of interesting. Amended notice of hearing. James Owens threw this out there at the last freaking minute. All right, let's see. Court minutes. Motion for statement of particulars, denied. We knew that. Motions for additional discovery, denied. We knew that. Motion to appoint forensic psychologist, as stated on the record. The court appointed Dr. Brennan. Motion for cost granted. Motion to appoint crime scene reconstructionist, as stated on the record. Motion of the return property, denied. We knew that. She wasn't going to get her phone or whatever she wants inside the phone. Motion for enlargement of time was granted in part and denied in part. It was granted as it relates to filing the objections to the state's evidence, denied as to remaining portions of the motion. And again, I'm going to go over these closer in separate videos. I'm going through each motion on each of these videos. The court will prepare order as stated on the record for remaining motions. I did my best, Judge. I did my best, Judge. Per the court heard several of the okay, let's read this right here. Let me see if I can enlarge this without making life crazy for you guys. Can y'all see that? Is that better? We'll have to remove Sarah so y'all can see this. Per the court, here are the following comments. The court heard several of the defense motions as it relates to motion for statement of particulars, which was denied. As stated on the record. Motion for additional discovery, denied, as stated on the record. Motion to appoint forensic psychologist, granted, as stated on the record. The court appointed Dr. Brennan. Motion for cost, granted, as stated on the record. Motion to appoint crime scene reconstructionist and death investigator, granted. Bring him in, please. As stated on the record. Motion for the return of property, denied, as stated on the record. Motion for enlargement of time, granted in part, but denied in part. Granted as it relates to filing objections to the state's evidence. Denied as to the remaining portions of the motion. The court will prepare order as stated on the record for remaining motions. All previous set dates remain. Okay, this is email correspondence from Christian Lake. I'm just going to show you guys all these items that I'm pulling up here. And it's talking about the Justice Administration for approving the money, right? Okay. Order on state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome, and state's motion in limine, and state's motion for examination by the state expert, and order on state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome. Whew. Let me take a breath after that one. Okay. The court, having reviewed the motion, having reviewed the response, having reviewed the amended motion, having reviewed the court file, having considered the authorities and arguments offered by counsel for the state, and having considered the authorities and arguments offered by counsel for defense, finds as follows. This matter is set for trial on October the 7th of 2024. On September the 6th, the defendant filed that certain notice of intent to rely on defense of battered spouse syndrome. Yeah, they did. The notice provides a statement of particulars showing the nature of the defense, BWS as a result of the physical and psychological abuse the defendant sustained at the hands of the alleged victim, Jorge Torrez Jr., and the name and address of a witness, Dr. Julie Harper. On September 6th, the state filed the motion. On September the 13th, the defendant filed the response. On September the 15th, the defendant filed that certain amended notice of intent to rely on the defense of battered spouse syndrome. The amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the notice and the names and addresses of 6 witnesses. On September the 19th, the state filed the amended motion. The court finds that both the notice and the amended notice comply with Florida statute, blah, blah, blah. Okay. And then he references Medina versus State as relied on by the state. All address conclusions of admissibility of expert testimony on battered spouse syndrome at trial, not pretrial exclusion of expert testimony on battered spouse syndrome. Additionally, review granted addresses the introduction of the battered spouse syndrome evidence, not the pretrial exclusion of the same. So does that mean he's saying let the jury decide? I guess so. The state relies heavily on Wagner versus State. In Wagner, according to the appellate's testimony, as she bent down to pick up the keys with her left hand, the gun she was holding in the right hand accidentally discharged, that she absolutely did not intentionally pull the trigger, and that she was not aiming at anything when the gun went off. The bullet discharged and struck her husband in the lower back. The trial court precluded appellant from presenting the battered spouse syndrome evidence at trial. And at the hearing, no outright evidence of an accident was presented. Interesting. Here's his orders as follows. The motion and amended motion are granted in part and denied in part. The motions and amended motion are granted in that the defendant shall submit an examination by an expert of the state's choosing. So, okay, state, you get to have your guy come in and talk to Sarah and do a little bit of a psyche bow on her. This is going to be interesting. Oh, this is going to get fun. But you got to do it no later than September the 26th. And honestly, we're going to be in court all day on September 26th with this trial thing. So he's basically saying, you better have it done before the pretrial conference because it's probably going to come up in pretrial conference. The motion and amended motion are denied, and that the notice and the amended notice is stricken. So we're going to allow it in. We're going to let them do their thing with this battered spouse syndrome, and we're going to let them shoot themselves in the foot. State request preclude defendant from mentioning battered spouse syndrome in her opening statements is denied. So James can get up there and lie all he wants to. Jamie Owens. Lie all he wants to. State's request to prevent, and remember, whatever he says in opening statements, they're not considered facts. The jury's not supposed to allow them to be considered as facts. State's request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence of trial is denied. We're going to go that route right now. Things could change as of September the 26th when they have their pretrial conference. And you guys, I'm telling you, every day I'm trying to stay on top of this docket because Owens is throwing stuff in there. Then the state is on it. The state comes back on it. Just they're so ready for him. And I don't think Owens has time to get it all done. And I want to say something. Those girls that were with Owens at the court, we're going to watch this in another video. Those girls were seat fillers. That's all that was. If you watch them during this whole thing, even when he was like freaking out trying to find something, those girls didn't have a clue what was going on. They didn't know where it was. You could tell they hadn't done the work on it. It was quite obvious that he was just trying to make it look like. Now you've seen this. Like this comes up a lot when you watch movies. Remember Erin Brockovich? Do you remember in Erin Brockovich when those attorneys came in and they just bombarded Julia Roberts and that attorney, and they were like, "Holy crap!" That's what James Owens is trying to do. He's trying to make it look like he's a big time money man, and he's not, because he can't even. Y'all, he's got one lady, and her name is Margaret, and she works back at his office. I bet you ain't got anybody else in that office. I'd love to see it. I'm gonna have to go back and look at his office. Let's see, where's his office at? We already looked at that, didn't we? Well, I can just tell by his website and everything. He's not. When he first came on board, I thought he was a big time player. I did. I thought he was respectable. This was before he spoke. I thought everything was cool. And now I'm looking at it and I'm like, no, 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 he's not. Court appointed experts to produce reports. I love that. I love that judge says, yep, they have to produce those reports. And that's all it. Okay, so stay tuned because I've got some more stuff coming out in the next couple of days where I'm breaking down each motion that they looked at in the hearing and just kind of doing my own little take on it. And I've got some more funnies for you guys too that I'm working on. The funnies actually take longer than anything, so bear with me. I just have to say something. Thank you so much for your support on my channel. Thank you so much for all your kind words and just cheerleading me through the things that I'm doing here. And I'm so happy that you guys are liking it. Please don't forget to share this into any Reddit forums you're in or any Facebook. I'm not on Facebook. Facebook, Instagram, wherever you want to share it, Twitter, whatever you're on, WhatsApp. I don't know about it. Whatever those TikToks, everything. Please feel free to share my content, and just make sure you put the link in there so that people can get back to here to watch it. I appreciate you guys so much. Thank you. Have a blessed day, and I'll be back very soon.